Okay, here we go. Let me go over here. And hi, everybody. I'm late because Kevin made me late because he was wanting me to see how Cher was walking with her new boyfriend, which I never got to see. Okay. Get some seltzer. Anyway, we have some stories here in the headlines tonight we're going to talk about, and we're going to talk about some other stuff after this, but the three that are the top headlines that we're going to cover is the Iowa man is charged with beating 4 people. There were 3, and then there's a 4th now. Hold on. My ad is playing here. And he beat them with a lead pipe. And the reason he did this is he thought maybe a movie would be made about this. And then we're going to read the case where the Tennessee Appeal Court reinstated the conviction of a woman who murdered her newborn twin sons, hid them in a laundry basket in the house, and they reinstated her conviction. And then this other person here is a former Georgia beauty queen, they call her. She is the title holder of what you see there in 2023. But now she stands charged for murdering her boyfriend's 18-month-old. So that's what we're going to talk about first and foremost tonight. And then I've got some other things. But hope that you guys had a good Sunday. Let me go here. Talk about the Iowa man first. His name is Luke Truesdell, 34 years old. And he was already charged with 3 murders, okay, because in rural Idaho and Iowa County last week, Lynn County officials say that they found Ramondus Cooper, 44, Keona Ryan, who's 26, and Amanda Parker, 33. They were dead in an outbuilding in the northern part of the county on Wednesday. Now a 4th person, 34-year-old Brent Brown, was badly injured and flown to a hospital for treatment. He died from those injuries on Friday. So now Luke Truesdell was already charged for the first 3. He's now being charged with Brown's death. He's expected to appear in court on Monday on the latest charge. Investigators say that Truesdell admitted beating the victims with a metal pipe, and according to the criminal complaint, he hoped that a movie would be made about the murders. Yeah. And investigators are trying to determine how he chose the victims. Was it random? They don't believe it was random. Parker was living in the outbuilding. Brown's father owned it. But investigators, including Lynn County Attorney Nick Maybanks, they're not saying much about the details of the crimes. And I quote, they said, "First of all, I want the public to know that they're safe. This was an isolated incident that occurred, albeit a very unfortunate one, and tragic one at that. Also, want the public to know that this case is being made a high priority and that it's been assigned to top prosecutors in our office and that we intend to do everything it takes to get justice for the 4 victims." And that's from Maybanks. That's a quote from Nick Maybanks, Lynn County Attorney. And the prosecutor said it's the first quadruple murder on record in the county. So the office will be pursuing life sentences for each of the murders if he is convicted. So yeah, he thought wanted a movie made about that. Okay. Then we go over. Let me put this over here. I meant to do for him, but we'll do for her. Okay, and then I'm going to get her paperwork here. All right, so keep in mind this is who we're talking about. We're not going to go through this whole thing, but that woman you just saw the picture of is Lindsay Brooke Lowe. And this is the Court of Criminal Appeals. Petitioner Lindsay Lowe was convicted by a Sumner County jury of 2 counts of first-degree murder and 2 counts of aggravated child abuse for killing her newborn twin sons shortly after their birth at her parents' home and concealing their bodies in a laundry basket. Her convictions and resulting life sentence was affirmed on direct appeal, and the Tennessee Supreme Court affirmed. Petitioner unsuccessfully sought a rehearing. Petitioner then sought a writ of certiorari in the United States Supreme Court, which was denied. Petitioner ultimately filed an untimely petition for post-conviction relief in which she made innumerable allegations of ineffective assistance of counsel as well as several constitutional violations that she argued necessitated reversal of her convictions. Petitioner also requested due process, tolling of the post-conviction statute of limitations based on erroneous legal advice about when the statute of limitations commenced. The post-conviction court determined due process tolling was warranted and permitted petitioner to have a lengthy hearing on the merits of the post-conviction petition. After the hearing, the post-conviction court granted post-conviction relief on the basis that a juror was presumptively biased against the petitioner, violating her right to a fair trial, and that trial counsel's failure to remove the juror violated the petitioner's right to effective assistance of counsel. The post-conviction court did not address the merits of any of the remaining claims in the petition. In this timely state appeal, we determined first that the post-conviction court improperly granted due process tolling of the statute of limitations for post-conviction relief. Additionally, because the post-conviction court went on to grant post-conviction relief, we renew those findings of fact and conclusions of law and determine that the post-conviction court also erred in finding that the juror was presumptively biased and the trial counsel was ineffective. As a result, we reverse and remand the judgment of the post-conviction court. All of the petitioner's convictions are reinstated and her petition for post-conviction relief is dismissed. So, let's just see what in September of 2011, the petitioner was a 25-year-old college graduate. She was engaged to be married. She worked at a dentist's office. She was living with her parents and her younger sister in her parents' home. Unbeknownst to her parents or sister, she was pregnant with twins, the father of whom was a man who was not her fiancé. During the night of September 12, 2011, the petitioner gave birth without assistance to live twin boys in the bathroom she shared with her sister. This kind of sounds like that Skylar, Brooke Skylar, whatever, right, that gave birth in the bathroom, right? To live twin boys in the bathroom she shared with her sister. She concealed the births and stifled her son's cries with her hand before she hid the bodies of her twins in a laundry basket and cleaned up the bathroom. She called in sick to work on the day of the deliveries. The next day, she was back at work. Her mother discovered one of the dead newborns in a laundry basket in the petitioner's bedroom. When the petitioner was questioned by police that afternoon, she admitted that she gave birth to 2 newborns and covered the mouth of each of the babies as she delivered them to keep them quiet. The second dead newborn was discovered in the bottom of the same laundry basket after petitioner's admission to the police. Petitioner was arrested and charged with 2 counts of first-degree murder, 2 counts of felony murder, and 2 counts of aggravated abuse. Petitioner sought the assistance of appellate counsel. Now, let's just look at this. Okay, this is September of 2011. Okay. So these kids would be turning 13. She was 25, and a college graduate. She was engaged to be married, working at a dentist's office. And she conceals a twin pregnancy, gives birth to twins unassisted in the bathroom. We don't know how many weeks. It doesn't say if they were early or what. Usually twins do come early, but she's giving birth unassisted. And unlike Skylar Brooke Richardson, who said that her baby she says her baby was stillborn. That's what I remember. She didn't do anything to stop the baby from breathing, but that here she admits that she covered their mouths, to keep them quiet, then hid them in a laundry basket, went back to work the next day. So it says she was arrested, charged with 2 counts of first-degree murder, 2 counts of felony murder, 2 counts of aggravated child abuse. Petitioner sought the assistance of appellate counsel, a local attorney with years of experience in criminal law. He was out of the country on vacation at the time and referred the petitioner to trial counsel, another highly regarded and experienced local attorney who practiced primarily in criminal law. Quickly, the case garnered quite a bit of media attention. I don't really remember this. Do you guys? Due to the nature of the facts, trial counsel moved for a change of venue, but that request was denied. Now, they're not saying, was this in 2011 that it went to court? I don't know. Based on the level of pretrial publicity, a written jury questionnaire was submitted to prospective jurors in advance of jury selection, including one woman identified as juror number 17, who ultimately was seated on the jury. According to the questionnaire, juror 17 was a 47-year-old, married, physical therapist with 2 children. Juror 17 watched the news daily and had heard about the petitioner's case on the nightly local news. Juror 17 responded to the question, "Have you formed an opinion based on what you've heard?" by marking the box next to yes. Juror 17 wrote that in her opinion, the petitioner lied and killed her 2 newborns. Despite that answer, Juror 17 marked yes when asked if she could lay that opinion aside and, based on the evidence and law, reach a fair verdict, and could sit as a juror in this case and listen to the proof and law and be absolutely fair. In the details section, Juror 17 indicated that she was honest and followed the law. As jury selection began, the trial judge gave routine preliminary jury instructions. The trial judge admonished prospective jurors about the importance of being impartial and the presumption of innocence afforded to criminals, defendants like the petitioner. When the first prospective panel was drawn from the jury, the trial judge addressed the prospective panel about pre-trial publicity and bias. The trial court excused several potential jurors because they said they could not or were not sure if they could be fair and impartial. The trial court did not, however, excuse potential jurors on the basis that they formed an opinion about the case based on pretrial publicity, but instead that they could be fair and impartial. As jury selection continued, the first round of presumptory challenges was exercised by each side. Juror 17 was seated on the jury panel with 7 other potential jurors. The trial court asked if any of the panel members had a hardship that would prohibit them from serving on a jury. The trial court then asked, do any of you have opinions or experiences or anything that would taint you to keep you from being fair and impartial in evaluating your duties as exclusive finders of the facts? The trial judge then specifically asked Juror 17 and another prospective juror, can you be fair and impartial before you hear any proof in this case? And Juror 17 answered, yes, sir. The other juror exclaimed, personally, I don't think I can. That other juror was excused. The trial court continued to question members on the panel about their answer to the above question, resulting in 2 more jurors being excused because they expressed an inability to be fair or had pretty well made up their mind about the case. Next, the trial judge questioned the jury panel about the extent to which they had heard or seen any pretrial publicity. Juror 17 was questioned with one other juror. One of them, identified only as prospective juror, indicated that she had heard about the case before coming to court. Juror 17 stated that she had not formed an opinion as to the guilt or innocence of petitioner, and that she could be fair and impartial. When specifically questioned by the state, Juror 17 admitted that she heard most of the information about the case from local TV when she saw the initial arrest. She denied watching much more news since then and denied any first-hand knowledge of the case. When the entire panel was asked, Juror 17 agreed that she could reach a guilty verdict if the state proved its case. Juror 17 also reported that she had adopted 2 children, but that the adoption would have no effect on how she viewed the case and did not have any problem giving both parties a fair trial. Counsel for the state commented that each prospective juror agreed to put aside both sympathy and prejudice while serving on the jury and would base their verdict on the law itself and evidence. Counsel for petitioner asked Juror 17 if she'd be able to stand her ground and vote her conviction if selected to the jury. She responded in the affirmative. Counsel again reviewed the questionnaires and asked Juror 17 how she heard about the facts of the petitioner's case. She responded that she watched the local news and immediately recognized the case at the time she received the jury questionnaire. Juror 17 reported that she had not discussed the case with anyone and that even if she saw photographs of the victims' bodies, she would be able to consider all the evidence. There was at least one other juror who filled out the questionnaire by responding that he had an opinion about the case. Trial counsel stated to the potential jury pool that people often form opinions about cases based on what they see on the news. This prospective juror admitted that his opinion has changed since filling out the questionnaire and that he felt he could be impartial. This juror was ultimately impaneled as an alternate juror. Trial counsel wrapped up his questioning with the following just one last time, just to make sure, is there anybody that has a problem, either with things that you're going to hear today, anything about the particular facts in this case that you think is going to make it difficult for you to be impartial, or is there anyone here that has some personal issue? None of the jury panel indicated a problem. Counsel for petitioner exercised all but one of the preemptory challenges that Juror 17 was seated on the jury. The case proceeded to trial. At the conclusion of the jury trial, the petitioner was convicted by the Sumner County jury of 2 counts of first-degree murder and 2 counts of aggravated child abuse. As a result of the conviction, the petitioner was sentenced to an effective sentence of life imprisonment. Petitioner appealed her convictions. Okay, we know that. So on September 5th, 2019, petitioner filed an untimely petition for post-conviction relief. We just read all of that in there. Now let's see. Appellate court counsel testified he recalled that he received a call about representing the petitioner at trial. He said he was out of the country when the petitioner was arrested, so he referred the petitioner's father, Mark Anthony Lowe, to trial counsel. Appellate counsel continued to provide what he referred to as tactical assistance to trial counsel during the trial and ultimately represented petitioner on direct appeal. After the direct appeal of petitioner's convictions was unsuccessful, appellate counsel talked to the petitioner about her remaining options, and they decided to file a petition for a rehearing in the Tennessee Supreme Court on a retroactivity question. Okay, at some point after that, Mr. Lowe recalled a conversation with appellate counsel in which appellate counsel advised Mr. Lowe to seek, let's see, we're not going to read through all this, hang on. Petitioner's parents met with post-conviction counsel on April 23, 2019. At that meeting, post-conviction counsel agreed about the miscalculation of the statute of limitations. Post-conviction counsel affirmed, so they're talking about a improper calculation. incorrect calculations. At the time, post-conviction counsel consulted with petitioner and her parents and filed the post-conviction petition along with a motion to toll the statute of limitations for due process concerns on September 5th, 2019. Okay. Post-conviction hearing, which spanned 3.5 days, there was testimony from 5 experts, 2 attorneys, petitioner, and Mr. Lowe. Some of the testimony is not relevant to the resolution of the issues. Mr. Lowe testified that he was seated inside the bar in the courtroom near the jury box during jury selection because there was not enough room for spectators in the gallery. Mr. Lowe testified that as the judge announced that the final jury was selected, that juror 17 gave a fist pump and said yes, while gesturing with her arm before looking around just a little bit with her eyes, wondering if anyone saw her. Mr. Lowe described juror 17's behavior as alarming. Trial counsel did not object or seek to have juror 17 removed from the jury. Trial counsel testified that juror 17 would not talk to the defense investigator after the trial. Trial counsel also reported that the alternate juror told the investigator that juror 17 had very strong opinions from the beginning and that she appeared to have an agenda and that she seemed hostile towards the petitioner. Okay. Okay, so now they're talking about the juror bias, which she said. Juror 7, okay, addressing the prejudice, juror 17 was untruthful, possibly lied outright about her preconceived opinion concerning the petitioner for lying and killing 2 newborns. That is something that is not dismissed from the mind easily, and juror 17 said nothing in voir dire about changing her opinion from lying and killing to no opinion at all. The court has concluded from the evidence that juror 17 either lied or concealed her opinion to carry that opinion into the jury trial. We disagree with the post-conviction court. The petitioner proved actual bias based on the answers about prejudicing the case. Moreover, we determine the evidence preponderates against the post-conviction court's conclusion that juror 17 said nothing in voir dire about changing her opinion from lying and killing to no opinion at all. Juror 17 explained that despite her opinion, she could be a fair and impartial juror. With regard to the fist pump gesture, we disagree with the post-conviction court's conclusion that the gesture indicated bias. There could be a litany of reasons to make such a gesture after being impaneled as a juror. Oftentimes, jury selection is a lengthy process. Juror 17 could have merely been expressing excitement that the selection process was over, or that she might finally get to exit the courtroom after a lengthy session. Juror 17 could have just been excited to get to participate in the judicial process. To presume a nefarious intent, a bias from the gesture without further explanation is misguided. We determined that the post-conviction court improperly determined that there was a willful concealment on the part of juror 17 that showed actual bias. In our review, we failed to see how petitioner proved prejudice by showing that there is a reasonable probability that, but for the counsel's unprofessional errors, the result of the proceeding would have been different. Because we determined that the post-conviction court improperly determined petitioner was prejudiced, there is no need for us to analyze the second prong. The post-conviction court improperly granted post-conviction relief. Conclusion. For the foregoing reasons, the judgment of the post-conviction court is reversed, and we dismiss the post-conviction petition. Petitioner's convictions are reinstated, and the matter is remanded to the trial court for any further proceedings which may be necessary. So that's it. That's Timothy L. Easter, the judge. And I would like to know a little more about the court case itself. Like, let me see, this woman, how many weeks pregnant was she when she gave birth to these twins? I don't know if any of you know about this case. I don't really remember this. They say there was a lot of publicity about it. I don't know if that was just in their little neck of the woods in Tennessee. Lindsay Brooke Lowe. Oh, there's another Brooke Schuyler Richardson. Lindsay Brooke Lowe. Let me just see what... Okay, let's see. Okay, so... Okay, so here's the state of Tennessee versus Lindsay Brooke Lowe. The parents of the defendant, Lindsay Brooke Lowe, discovered the body of one of her newborn twins in a laundry basket in her bedroom. A second deceased newborn was also found in the basket. The defendant gave an incriminating statement to the police. A jury convicted the defendant of 2 counts of first-degree felony murder. Okay, we went over that. Let me see if they give us any factual procedural history. Let's see here. The defendant was interviewed by police and ultimately gave a statement in which she admitted placing her hand over each baby's mouth in order to stifle the child's cry. Prior to trial, the defendant moved to suppress her statement. On November 5th, 2012, the trial court held a hearing during which the state presented the testimony of Detective Steve Malik, who had obtained the defendant's statement. The defense focused primarily on showing that the Miranda warnings given by Detective Malik were not adequate. The defendant also tried to introduce the testimony of Dr. Pamela Aubel, a forensic psychologist who had examined the defendant. The state objected to the testimony, and the trial court ultimately excluded it because Dr. Aubel had not reviewed the interview between the defendant and Detective Malik. Okay, I'm trying to see when I want to hear about the details of how she concealed this. At the trial, the state presented evidence tending to show that the defendant became pregnant after having sexual contact with a man who was not her fiancé, and that she hid the pregnancy because of a fear of its social consequences, and that she suffocated her children to keep her family from discovering the births. The defendant presented evidence tending to show that she became pregnant after being sexually assaulted, that she did not, due to pre-existing mental defect, realize that she was pregnant at any time during the pregnancy, that giving birth unassisted affected the defendant's mental state and physical capabilities, and that the deaths of the children were not intentional or premeditated. The defendant grew up in Hendersonville, Tennessee, lived with her mother and father and younger sister. The defendant's father and sister testified that she attended a private religious school and was involved in numerous activities such as swimming and dance. This almost reminds me of that younger, but that girl was in high school at the time, and she put her baby in a laundry, no, I think it was in a box with record albums or something. The defendant was close with her family and was always well behaved and meek. In 2005, while the defendant was away at college, the defendant's mother, who had previously run the home in addition to working, developed a benign brain tumor the size of an orange. After surgery, the defendant's mother underwent a change in her personality, and she was no longer able to plan, clean, organize, or make financial decisions, and she experienced emotional highs and lows. The defendant tried to fill her mother's place by cleaning and getting groceries and doing other domestic tasks when she came home from college on the weekends. The defendant had become engaged to Jonathan Brooks at college, but after she graduated in 2008, she moved into her parents' house to assist her mother. The defendant remained engaged to her fiancé, but the two lived in separate cities, both before and after his graduation in 2009. The mother of the defendant's fiancé became ill, and the relationship between the defendant and her fiancé gradually became more distant. Okay, that's around April or May of 2010, the defendant met Jeremy Smith through her cousin's husband. Mr. Smith began to send text messages to the defendant. The defendant's sister testified that she knew that Mr. Smith had been bothering the defendant, but was not aware that the defendant at some point began communicating with him. Mr. Smith testified that he went on 3 dates with the defendant, had sex with her each time, and used protection only on the first 2 occasions. He tried to call her after the 3rd date, but she did not return his call. Mr. Smith testified that there were several twins in his family and that he himself was a twin. He acknowledged that he had told the defendant he wanted to marry her and wanted her to have his children before they ever went on a date. And while he had a girlfriend, he denied that the defendant had told him that she did not want to have sex or that he forced her to have sex with him. He acknowledged that he actually called her 4 times after their last meeting in early January 2011, but that she would not return his calls. So January 7, December, November, October, they really weren't early. Maybe a few weeks. Okay. In the series of in late November, wait a second, where was I? He testified that he would have taken care of the babies and at first denied that he failed to pay child support for an existing child. However, he ultimately acknowledged that he had been charged with flagrant non-support of his daughter. The defendant's text messages with Mr. Smith were introduced through Special Agent Reeves Garnett. In late November 2010, the defendant and Mr. Smith exchanged numerous flirtatious messages. In one of the messages, the defendant asked Mr. Smith to join her at a restaurant and bar. When he responded that he was with his girlfriend, she asked him, "Why did you ask me to marry you if you were with her?" Mr. Smith responded, "Because I want to marry you. I want you to be the mother of my kids." The two exchanged messages, apparently attempting to arrange a meeting around December 22nd of 2010. The defendant became pregnant by Mr. Smith, and she was carrying twins. However, she did not tell anyone about her pregnancy. The defendant's father testified that he never knew or suspected that she was pregnant, despite the fact that it was not unusual for the family to go into the defendant's room. The defendant's sister likewise testified that she never knew or suspected that her sister was pregnant, even when she was carrying twins in her 9th month. She never heard anyone speculate that the defendant was pregnant. In the spring of 2011, the defendant's fiance's mother died. At around the same time, the defendant's mother suffered a return of her brain tumor, and the defendant tried to help around the house and drove her mother to radiation therapy. The defendant had been unable to find work in her field after graduating in 2008, so at some point in the summer of 2011, the defendant obtained work doing billing and insurance claims at a dental office. In August, she was transferred to a branch closer to her home. Terry Farrell, who worked with the defendant at the new location, testified that she never suspected the defendant was pregnant. All the workers at the dental office, even those in billing who did not have patient contact, wore scrubs with an optional lab jacket, and the defendant wore a black lab jacket every day. Michelle Stambach, the defendant's supervisor, also did not know or suspect that the defendant was pregnant. She testified that no one at work knew about that or suspected the pregnancy. on the weekend of September 10th, 2011, the weekend before the birth of the twins. The defendant was a bridesmaid in a friend's wedding in Kentucky. The defendant's sister, Lindsay Lowe, testified that although the defendant had been fitted for her dress in January or February when she was only a month or two in her pregnancy, the dress still fit the defendant in the 9th month of pregnancy when she wore it to the September wedding. The defendant's sister and a friend named Lacey McFadden, isn't that funny? They're both named Lacey, drove with the defendant from Hendersonville to Kentucky to attend the wedding. Although the young women in the wedding party were all changing in front of each other in the same room, no one noticed the defendant was pregnant because she didn't look any different. The defendant's sister had noticed that the defendant had gained some weight, but her weight had always fluctuated, so she didn't ascribe any significance to the weight gain. The defendant usually wore scrubs to work and big T-shirts at home. The defendant, her sister, and Ms. McFadden returned to Hendersonville on Sunday, September 11th, 2011, and Ms. McFadden slept in the defendant's bed with her. The defendant went to work on Monday the 12th, exchanging a series of text messages with her sister about going to a concert with her fiancé, about a trip they planned to take together with Ms. McFadden. That evening, the defendant's family believed that the defendant had a stomach virus. The defendant stayed in the bathroom she shared with her sister, and the defendant's mother went to the door 3 times to knock and check on her, accompanied by the defendant's father during one visit. The defendant told them that she was fine but sick. Because as a child she always asked to be left alone when sick, her parents did not think this was unusual. The defendant's sister had stayed in her own room and was not aware that the defendant was ill until her parents told her. At around 10:30 p.m., the defendant's sister sent her a text message saying, "Let me know if you need anything. Love you. Good night." At some point during the night, the defendant gave birth to twins in the bathroom. On Tuesday, September 13th, 2011, at 6:03 a.m., the defendant sent a text message to a coworker asking for the phone number of Ms. Stanback, her supervisor. The defendant then sent Ms. Stanback a text message identifying herself and saying that she'd been up sick all night and was still not well. She told Ms. Stanback that she could not come to work but would be at work the following day. Early in the morning after the births, the defendant's sister used their shared bathroom. She did not notice anything unusual about the bathroom. While the defendant's sister was in the bathroom, the defendant called her name and asked her for a glass of water. The defendant's sister made sure the defendant did not need anything else and then went to work. The defendant's father got ready to go to work himself to take his wife, who could not drive because of her tumor, to work. He believed that the defendant had a stomach flu, and he did not see her before he left. The defendant was home alone all morning with access to 2 vehicles. When the defendant's father returned home for lunch, the defendant was lying on the couch in an upstairs common area, and she seemed unwell, but she told him she was better. The defendant spent the afternoon at the house by herself, again with access to 2 vehicles. The defendant's sister got her some Jell-O and crackers from the store on the way home. And during the day of September 13th, the defendant sent several text messages. She sent her fiancé a text message around noon telling him she loved him. She sent some text messages to a friend, Rachel Hawkins, who was pregnant and due to deliver in early September. Ms. Hawkins told the defendant that she would be induced the following week if the baby had not arrived. The defendant responded, "Aw, I'm sorry. Well, I've been thinking about you. Hopefully she will get here before Monday." The defendant also discussed watching a television show called The Vampire Diaries with Miss Hawkins. If Miss Hawkins' baby had not arrived by the time the show aired, in a series of text messages with her sister, the defendant discussed the upcoming concert they were attending. She also sent some text messages to another friend regarding the concert and regarding her stomach bug. The defendant stated that she never went to bed last night. "I just laid on the bathroom floor." The defendant also told her fiancé that she had had a virus via text message that evening. The next day, the defendant left for work in the billing department of the dental office at 8:02 a.m. She sent her father a text message telling him that in the billing accounts, She had just come across a man who shared a name with one of her father's relatives. She also sent a text message to her fiancé at 8:35 regarding information on a cabin they intended to rent for their trip. The defendant's father testified that the defendant's sister had left for work and that his wife was upstairs. The defendant's father heard his wife shout his name in a panicked voice. She told him that there was a newborn child in the defendant's room. The defendant's father looked at the child and spent about 15 minutes unable to do anything due to shock. He then called a friend of the father's who is an attorney, and this man told him to call his pastor. He called his pastor, who started for the house, but advised him to call the authorities. The defendant's parents did not go upstairs again. Randy Tope testified that he was answering calls with the Hendersonville Police Department dispatch on September 14, 2011, when he received a telephone call, which was played for the jury, from the defendant's father at 8:30 or 8:35 a.m. The defendant's father stated, "My daughter's gone to work, but apparently she has had a child in her room, and it's not living." Mr. Tope dispatched the police department, fire department, and emergency medical personnel. Officer Jeremy Fentress was the first on the scene. He testified that the defendant's father told him that his 25-year-old daughter had been sick and that his wife went to clean his daughter's room that morning. They had found a deceased newborn in a laundry basket by the bed. Officer Fentress checked on the infant, who was under a sheet and a bloody towel, and found him cold to the touch and not breathing. Barbara Jones, a paramedic, arrived on the scene and examined the infant, who was obviously deceased. She touched the infant's arm and found no rigor mortis. Ms. Jones testified that it would take 12 hours to reach full rigor and about 12 to come out again. She concluded that the baby had come out of rigor mortis. Ms. Jones testified that there was fecal matter on the towel, but that the fecal matter could have been drained out as the muscles relaxed after death. She testified that there was no meconium stain on the baby, which can be an indicator of fetal distress. The baby appeared to be full term, and she estimated he weighed 5 pounds. Law enforcement officers all testified that the defendant's mother and father were very cooperative. Detective Sergeant Jim Vaughn testified that he arrived on the scene shortly before 9 a.m. and assigned Detective Malik to interview the defendant. The defendant's father testified that he told Detective Malik with the defendant where the defendant was, and that he was concerned for her health because her blood type was Rh negative. He asked Detective Malik to take her to the hospital. He also asked Detective Malik if he could have an attorney present when police talked to the defendant, and Detective Malik replied that she was too old. Detective James Garrett was taking written statements from the defendant's parents when Detective Malik was interviewing the defendant at the police station. Now that's strange that he said she was too old to have an attorney present. That's wrong. Okay. Detective James Garrett was taking written statements from the defendant's parents when Detective Malik was interviewing the defendant at the police station. Detective Garrett testified that he received a communication from an officer at the station that there was a second baby in the home. Although the search warrant... Hold on a second. Although the search warrant had not been obtained, Detectives Vaughn, Garrett, and Fentress went upstairs to check on the welfare of the second baby. Detective Garrett removed the sheet and towel from the basket, put them on the bed, intending to lay the first baby there. However, he discovered that the first baby's umbilical cord was attached to something in the basket. So Officer Fentress held the baby while Officer Garrett removed some items from the basket and discovered the second baby and the placenta. The second baby had the umbilical cord lying across his neck and shoulder, but the cord was not wrapped around the baby's neck. After determining that the second child was deceased, they replaced the babies in the basket. Officer Fentress acknowledged that his report stated the second baby was significantly smaller than the first and appeared to be only 3 or 4 pounds. Detective Garrett brought the basket out to the emergency vehicle, backed up to the door, and he attached tags to the baby's ankles to distinguish them. The baby who had been discovered first was tagged Baby Lowe 1, and the other one was tagged Baby Lowe 2. The officers all testified that the defendant's home did not contain any baby items or any supplies for taking care of a newborn. Detective David Harrell prepared the search warrant for the defendant's room and executed it. He testified that he saw no blood in the bathroom. However, testing indicated that there was blood or biological material on the bathroom floor, covering the toilet and on a patch of carpet in the defendant's bedroom. In the closet of the defendant's bedroom, Detective Harrell found numerous blood towels and sheets and several pairs of bloody underwear and pajama pants and a bloody shirt. He also found a Kendall Curity maternity pads package for 12 pads in a trash bag in the defendant's room. In introducing photographs of the physical evidence found at the defendant's home, a picture of a shelf containing a series of books or videos of the Vampire Diaries were admitted over the defendant's objection. The trial court ruled that the photograph was very relevant to the issue. Okay, an autopsy was performed in an attempt to determine the manner of the twins' death. Dr. Brent Davis, forensic pathologist, testified that the gestational age of baby Lowe number 1 was 40 weeks and that the baby weighed 6.5 pounds and that he suffered from no abnormalities. The second baby had the same weight, gestational age, and absence of birth defects. So she had 2 babies, 6.5 pounds each. Full-term twins that she delivered by herself in the bathroom. That's quite amazing. And that she wasn't even freaking out or anything else about that whole thing. Are you kidding me? That is crazy, isn't it? That's nuts. Okay, so let's remember. I want to see if we can get a picture of what she looked like back then. I hadn't heard about this case either, Kevin, but let me see what... Let's see this. Okay, so let me see when this was from. December 2011. Okay, so okay, let's go back to the document here. Okay, so the autopsy was performed, right? That he suffered. The second baby had the same weight, gestational age, and absence of birth defects. Both babies had a subgaleal hemorrhage, which is a minor injury common in vaginal birth. Dr. Davis testified that if a baby were to die in utero or born deceased, the lungs would not be aerated and would not float. The lungs of both babies floated and were aerated when examined under a microscope. Dr. Davis testified that this meant that both children were born alive. The second baby had the umbilical cord around his neck. However, Dr. Davis testified that he examined the neck tissue, found no indentation or hemorrhage in the neck muscles, indicating that this baby was not strangled by the umbilical cord. Dr. Davis's report concluded that the babies were victims of homicide and the manner of death was smothering. Dr. Davis also testified that smothering comes down to a documentation to a lack of injuries. He elaborated that a conclusion that a baby was smothered was typically based on scene investigation in the absence of another obvious cause of death. He acknowledged that he relied heavily on the information given by law enforcement. He also testified that the placenta, if delivered on top of the babies in a toilet bowl, could suffocate one or both. He stated that it was possible that one baby delivered on another could suffocate the first baby. Dr. Davis testified that newborns typically cannot regulate the body temperature well, and that hypothermia could kill a newborn, particularly in water, in a matter of minutes to an hour. He stated that hypothermia would also leave an absence of physical findings, and that a baby who died of hypothermia would look the same as one who died of smothering. He also acknowledged that a mother who delivered without medical attention could lose consciousness, particularly if suffering blood loss, and that she might not be able to tend to the babies, and that they could die of exposure as a result. Dr. Michael Baird testified that the twins were fraternal, and that genetic testing indicated that Jeremy Smith was the biological father of both. The defendant's fiancée, Brooks, was excluded as the father. The state introduced the testimony of Detective Malik and the defendant's video recorded statement as evidence that she had intentionally killed her newborns. The defendant introduced the testimony of Dr. William D. Kenner and Pamela Auble to establish that the defendant did not realize she was pregnant and that she suffered from mental defects and hypovolemic shock at the time of the births, rendering her incapable of forming the intent to commit the crimes. Detective Malik testified that he was called to the defendant's home, and after he observed the first baby, he spoke with the defendant's father, who told him that the room belonged to the defendant and that based on the text message he had received that morning, she was at work. Detective Malik left to interview the defendant at her workplace, and he was driving an unmarked vehicle and wearing a suit. At the dental office, Detective Malik told the defendant's supervisor that he'd like to talk to the defendant privately. The defendant was at her desk, wearing headphones and smiling. She agreed to speak with him in private. Detective Malik identified himself as a police detective and asked if she knew why he was there. When she said she did not, he told her that they found the laundry basket. The defendant became serious at that point. He explained that he was trying to find out what had happened, and he asked her for cooperation. He told her that he'd like to talk with her at the station and that he would read her rights when they got there. Detective Malik told her briefly what her rights were. She told him that she would like to go to the station with him. He relayed to the defendant his concerns that she might not be able to drive. He told the defendant that he would drive her, and she wound up coming with him. The defendant retrieved something from her vehicle before leaving the parking lot. She sat in the front seat with no handcuffs, and Detective Malik never searched her. She had a purse with her, and they did not speak about the babies on the way. Instead, they had a casual conversation, which Detective Malik used to establish a rapport. At the station, the defendant sat on a bench in the hallway while the detective prepared the room. No one was watching her. In the interview room, he read the defendant her rights, and she orally waived them. During the interview, the defendant told Detective Malik that she knew she was pregnant probably almost the whole time, because she was not menstruating and was feeling different. She noticed she gained weight and began lactating shortly before the birth. She at first told Detective Malik that her fiancé was the father, but later told Detective Malik that she cheated on him with Jeremy Smith right before. She stated that she had intercourse with Mr. Smith twice, once at the end of December and once in early January, and that Mr. Smith did not use protection. She said she had not told anyone she was pregnant because she was just scared of what her family would think, and she did not want her family or fiancé to be disappointed. She also did not want to risk losing her fiancé. The defendant told Detective Malik that she was gone to the wedding from Thursday to Sunday. She stated that her stomach was hurting her on Monday, but she went to work. She did not have dinner and began to have intense back pain at about 6:30 p.m. She had a bowel movement at 9:30 or 10. Shortly after 10, she thought she was going to have a bowel movement, and instead she gave birth on the toilet. The defendant said the baby landed in the toilet bowl and that she lay down on the floor shaking. During the interview, she stated that the baby cried for less than a minute, and she denied touching the baby. She did not see if the baby was submerged. At one point, the defendant told Detective Malik that there were two babies and that the second one was also in the laundry basket. Detective Malik left the room to get a tissue, but also alerted another officer that law enforcement should check on the welfare of the second baby. The defendant initially stated that the second baby was born 5 minutes after the first and never cried. She told Detective Malik that she got off the floor, delivered the second baby and placenta into the toilet bowl, then laid back down on the floor. She raised the possibility that the second baby might have bumped into the first one as it was born. The defendant stated that both babies were alive when they were born. She said she never looked at them and did not know what sex they were or if they were moving. The defendant said she laid on the floor for about an hour and could not move. She told Detective Malik that her family came to the door 2 to 3 times after she had delivered the babies, but she told them she was ill and she did not need anything. She explained that at 3 or 4 a.m. Tuesday, she used a towel to retrieve the children and put them in the basket. She then cleaned up the bathroom floor and washed herself. She moved from the bathroom floor to the bedroom floor and finally got into bed. At 6:30, she heard her sister getting ready, and her sister asked her how she was. The defendant told Detective Malik that she could not move, and hold on a minute. And she stayed in bed until noon, at which time she moved to the couch. She did not check on the baby. She put the clothes she had worn into the closet. She moved to a different couch later in the day, and then she went to bed. Next day, she went to work. She stated that she had no plan for what to do with the deceased children. The defendant told Detective Malik that although her mother sometimes did laundry for her, she did not think her parents would find the children. Detective Malik had told the defendant that during the autopsy, the medical examiner would be able to tell if the babies were drowned, if they were thrown against a wall, or if someone had their hand over their mouth. He urged her not to ruin the fact that she had been cooperative and to tell him if there was more to the story. At this point, the defendant said that she did look at the sex of the baby and saw that he had a bowel movement. Detective Malik then assured her she was a good person who had made mistakes, told her that the autopsy would reveal what happened, and told her that he sensed she felt guilty. The defendant then told Detective Malik, I guess it was more. The first time was a little louder, so, I don't think they're definitely not like drowning, but maybe just kind of like, I don't know. I don't want to call it smother. I was just trying to keep them quiet. How were you doing that? She said, I just put my hand down there over their mouth. Over the baby's mouth? She nodded her head. How long would you say you did that for? She says, not very long. He says, until it stopped crying? She says, I guess, I don't know. Question, I understand. And then she says, oh my God, I know, it's okay. The defendant told Detective Malik that with the second baby, it was just the same thing. I guess I just put my hand over the mouth. She stated that there was not as much crying with the second baby. Detective Malik then summarized the defendant's statement. She agreed that she had put her hand over the first baby's mouth and that what she did so, she knew he could not breathe. She agreed that she killed the baby. She agreed that she put her hand over the second baby's mouth and that she knew that she killed him. The defendant agreed that they were clearly alive and that she clearly killed them. Detective Malik testified that he attended the autopsy and told the medical examiner that the defendant had said she smothered her babies. The defendant's version of events was introduced primarily through the testimony of her psychiatrist, Dr. Kenner. Dr. Kenner, who acted as the defendant's treating psychiatrist, testified that he had interviewed the defendant for over 13 hours, had interviewed her parents, and had reviewed her statements as well as her medical records, text messages, and psychological reports. His testing revealed that the defendant appeared to be answering the psychological test questions honestly. He testified that the defendant is a quiet, timid, passive person who froze and became numb in a challenging situation and who would rather have an interviewer fill in the blanks than present her own memories. Dr. Kenner testified that from ages 3 to 13, the defendant suffered from bladder infection, spasms, and incontinence due to a urinary tract malformation that required multiple surgeries during her childhood. Dr. Kenner testified that she used disassociation to cope with the pain and the embarrassment of the prolonged medical treatment. When she was in a dissociative state, the defendant would feel as though events were happening to someone else. Dr. Kenner testified that during high school, the defendant would come out of class and have no memory of having attended, and that was indicative of disassociation. He testified that after the birth, she mixed up appointments and arrived at incorrect times to her appointments with him. He testified that this was also typical for dissociative patients. Due to her medical history, the defendant would cope with stressful incidents by entering a disassociated state. Dr. Kenner testified that the defendant's description of her 2 sexual encounters with Mr. Smith led him to conclude that she had been SA'd. During the first encounter, she went to watch a movie at Mr. Smith's grandparents' home and discovered the television was in Mr. Smith's bedroom. The defendant resisted Mr. Smith and told him she did not want to have any relations with him. Mr. Smith kept pressure on her thighs, causing her pain, and eventually she decided to just get it over with and asked him to wear a condom. Dr. Kenner said that her dissociative disorder kept her from fighting and caused her some amnesia about the event. On cross-examination, he stated that in their second encounter, the defendant was at a friend's house and had been drinking. Mr. Smith asked her if he could come. Because she knew he didn't have a license, she told him he could come, believing that he would have no way to get there. She did not remember anything that happened after he arrived. Dr. Kenner testified that the defendant suffered from pregnancy denial, which is sometimes associated with trauma from SA. He stated that the pregnancy denial would have physical effects. For instance, the fetus would be carried vertically so that the woman would not appear pregnant to others. A woman suffering pregnancy denial might have lucid moments acknowledging the pregnancy, but would in general not know she was pregnant. Dr. Kenner stated probably 99.5% of the time she considered herself not pregnant. There were probably these oh shoot moments, when something came to her like, I know I'm pregnant, that would typically happen with these women. He testified it would not be uncommon for the woman when she was confronted with the irrefutable evidence that she was pregnant after delivery to say that she knew she was pregnant during the pregnancy. At the time, the denial would be over. The defendant never dreamt of babies or decorating while pregnant, which was a sign of pregnancy denial. He also explained that she had clear liquid come from her breasts prior to the birth and that she thought she had cancer. Dr. Kenner acknowledged that the defendant had stated that she knew she was pregnant to Detective Malik and Dr. Obel, and that Dr. Kenner stated that this was a realization she had in retrospect and not and did not indicate that she did not suffer from pregnancy denial during the actual pregnancy. Okay, let me see now. Prior to trial, the defense had moved to exclude certain Google searches retrieved from the defendant's telephone. The prosecution stated that it did not intend to use the Google searches in its case in chief, but it intended to introduce them in rebuttal if the defendant's expert testified that she was not aware of a pregnancy. Accordingly, in cross-examination, the state attempted to cast doubt on Dr. Kenner's diagnosis of pregnancy denial by cross-examining him on certain Google searches performed by the defendant's cellular phone. The state asked Dr. Kenner if he was aware that the defendant's telephone was used for the following Google searches: pregnancy calculator on September 3rd, 2011, pregnant and doctor porn on September 5th, 2011, free videos of pregnant sex, things to make you go into labor, and pregnant women and doctor porn on September 6th, and how to make yourself go into labor on September 9th. Dr. Kenner testified that persons suffering from dissociative disorders can split off segments of behavior, and that the defendant might perform these searches and still generally be unaware of her pregnancy. Dr. Kenner stated that the defendant believed she was dying at the time of her birth and did not know she was having a baby until she felt an ear. He also testified that the defendant did not try to smother the baby, but that she told him that she pushed on the baby. She had stated that she did not feel the baby's mouth or any other body part, but that the place she touched was just kind of plain, indicating that she was trying to comfort the baby by patting his back. Dr. Kenner stated that he had diagnosed this defendant with post-traumatic stress disorder, chronic dissociative disorder, and not otherwise specified, and major depressive disorder, chronic and severe. At the time of delivery, the defendant was also suffering from delirium brought on by the hypovolemic shock due to blood loss. Dr. Kenner recounted the defendant's descriptions of feeling dizzy and lying on the floor and beginning to black out as soon as she attempted to sit up after delivery. She recalled her head bouncing off the bathroom floor several times. Dr. Kenner testified that delirium would cause confusion, such as that was suffered by dementia patients. He testified that at the time of the births, the defendant was not able to form the requisite mental intent to commit the crimes, that she suffered from diminished capacity. Dr. Kenner also noticed that the defendant was still suffering from blood loss a few days after the birth. The nurse at the jail described her as suffering from pallor, dehydration, and crusty lips. She was also described as feeling dizzy and coming close to losing consciousness in her conversations from jail with family members. The defense sought to have Dr. Kenner testify regarding the reliability of the defendant's statement to the police. During an offer of proof, Dr. Kenner testified that he had professional knowledge of interrogation techniques and false confessions. He described the defendant as the low-hanging fruit of coercive interrogation. He noted that she said, "I guess," in front of many of her answers, and that her statement was inaccurate. However, he also testified that he could not say whether her statement was true, but her statement was so contaminated by Detective Malik's narrative that we don't know if it is true or not. The trial court decided not to permit testimony on the reliability of the statement because it found that Dr. Kenner's testimony was not credible and would not substantially assist the jury. The trial court also excluded Dr. Kenner's report regarding the voluntariness of the statement. Okay, so let's see. Dr. Pamela Auble, a forensic psychologist, evaluated the defendant 10 days after the births, and she testified the defendant was passive and introverted, and that she coped with stress by withdrawing, and that Dr. Auble also concluded the defendant used dissociation to distance herself from unpleasant events. The defendant did not think logically, and she reacted emotionally. The defendant told Dr. Auble that she knew she was pregnant but dealt with it by forgetting about it or telling herself that she was sick. The defendant said, "It runs through my mind 1,000 times a day. Why didn't you ask for help? But I just wanted to die." The defendant told Dr. Auble that after the first baby was born, my mind shut off, all feeling and everything. It all went away. I don't know. I just wanted it over. She said that she did not look at the baby, but she stopped the baby from crying by putting her hand on him. She lost consciousness. She pretended it was not happening. And more than that, it wasn't happening to me. The defendant remembered very little of the second birth. She thought she was dying because she was losing blood, shaking, and because whenever she attempted to get up, blood would gush and she would start to black out. She told Dr. Auble that she also stopped the second baby from crying. Dr. Auble testified that she relied on Dr. Kenner's diagnosis that the defendant was suffering from delirium. She also diagnosed the defendant with depressive disorder, chronic dissociative disorder, and post-traumatic stress disorder. She stated that the defendant was unable to form the intent for first-degree murder. Dr. Auble acknowledged that the defendant told her the biggest mistake had been being unfaithful to her fiancé. She acknowledged that the defendant was able to clean up herself in the bathroom, move the babies, and notify her work after the birth. In rebuttal, the state introduced the testimony of Dr. John Hutton, a forensic psychologist. Dr. Hutton agreed that the defendant suffered from a severe form of major depression and from post-traumatic stress disorder. He did not find that she suffered from dissociative disorder. But he concluded that the finding would not make much difference because even if she had been suffering from dissociative disorder, she would not have lost her cognitive abilities, but would simply have felt that she was not part of the events around her. He concluded that she did not suffer from dissociation because she did not have a history of getting lost driving or an inability to be on time, and because the defendant's home was neat in the downstairs and common areas and very messy in the bedrooms and private areas, indicating that the person taking care of the home was making rational decisions about where to clean. He also rejected the idea that she was dissociative based on the fact that she was able to turn her family away when they offered help, and because she was able to thoroughly clean up the evidence of the births. He also suggested that if she had been in pregnancy denial, she would have sought help with the birth because she would have believed it was an illness. Dr. Hudson testified he felt the defendant had the mental capacity to commit the crimes with which she was charged. Dr. Hudson testified he was very concerned that the defendant might be suicidal when he saw her in 2012, and he agreed that she might have memory loss from the event and that disassociation could occur as a defense during trauma. He also agreed that extreme blood loss could cause a loss of consciousness and hallucinations. During trial, the record indicates that the defendant became emotional numerous times. After the testimony of the first witness, Mr. Tope, the trial court had the jury take a break, and they asked the defense counsel, is she okay? And can she do a little bit better on the crying? It's a double-edged sword. The defense counsel indicated that they would like a break to allow the defendant to calm down, and the judge responded that they should let him know whenever they need to take a break. During the testimony of Agent Reeves, the court again took a break to accommodate the defendant's emotional response. Defense counsel noted that the defendant was receiving mental health treatment and had been avoiding looking at some of the evidence. The trial court noted that my bottom line here is that I want to be sure if she's in a position to assist you. After the testimony of Mr. Smith and out of the jury's presence, the trial court spoke to defense counsel. I'm concerned about your client. She is acting like a child. She has her head down, her ears covered, and I'm not going to tolerate that. Is she on medication? Is she okay? In chambers, the trial judge elaborated on the conduct. Now, I know this is an emotional trial, and we had a problem yesterday, and it was handled. But today, during the testimony of Jeremy Smith, I looked over at her many times, and she looked like a child that wasn't getting her way. She had her head down, covered her ears, like she didn't want to listen, and I could tell I couldn't tell if she was awake or asleep. I can't have her emotions being on display in front of the jury. Their job is difficult enough, and I'm going to tell you and I'm going to tell her if it happens again, she's going out of that courtroom. I'm going to warn her. The trial court stated that it did not want the defendant's behavior to influence the jury. Defense counsel noted that the previous day the defendant had been writing Bible verses over and over again on the advice of a psychologist, and the court stated it was unbelievable what she was doing. She was just over there, wham, wham, just not paying attention to anything, just in her own world. The trial court stated to counsel that the defendant would have to endure the trial and not show emotions, noting that the court could take a recess whenever the defendant needed it. The court concluded that I'll be sensitive to it. I know it's emotional, but I can't have this. The parties then returned to the courtroom where the defendant was present, and the trial judge admonished the defendant. Now, 2 times in 2 days, I've had to bring the attention of the defense, the emotions of the defendant that are being displayed to the jury. The emotion was displayed yesterday, and I've dealt with the problem yesterday, and it was handled. But today, the testimony of Jeremy Smith, the defendant, looked like a child sitting over there with her head down, ears covered, like she didn't even want to listen to the testimony. And I honestly couldn't tell if she was awake or asleep. I've told the defense that I will not have her emotions be on display for this jury. Their job is difficult enough. This case is extremely emotional, and I know I'm trying to be sensitive to the emotions of the defendant. So, Ms. Lowe, this is the way it's going to be. It's happened 2 times that your emotions have been on display in front of the jury, and I have asked the defense to let me know if you need a break, we'll take a break, but you sit there and you don't show any emotion to the jury. Like I said, their job is hard enough. We are doing the best we can. We can to keep all the emotions out of this case, away from the jury, so that they can decide this case on the evidence and the law. I will not have you sitting there acting like a child or displaying emotion uncontrolled. The next time that this happens, you will be excluded from the courtroom. I have set up the way that things will be handled from this point on. They will be handled this way. We will watch your emotions, but I'm not going to deal with any more in the way that we had to. Do I make myself clear? During the in-chamber conference about the testimony of Mr. Smith, defense counsel also stated to the court, Judge, you know we're dealing with a young lady who has some pretty significant mental health issues. She's mentally ill. The problem it poses for us is that I have spent a lot of time going over with her testimony, and I don't think I'm going to be able to call her as a witness and in her own defense, simply because I don't think she can do it. I don't think she can emotionally get through it. The defendant did not testify at her trial. Prior to the defendant making the decision, defense counsel told the court the defendant dreads testifying, and that although he had originally anticipated calling her, the defendant had come to the conclusion that she did not want to testify. During the hearing, the defendant told the court that she had decided not to testify because I just don't feel like I could emotionally handle it. She agreed that she'd been crying moments before when they discussed the possibility. Trial counsel moved for a mistrial on the basis of the trial court's comments to the defendant. The trial court denied the motion, noting that although it was sensitive to the mental health situation of the defendant, it found the defendant's action of putting her head down and covering her ears with her hands was a known intentional response, and it was childlike. The jury convicted the defendant as charged on all counts. The trial court held a sentencing hearing to determine the length of the sentences. The defense submitted a scrapbook of the defendant's life and 88 letters of support written by family and friends. The letters spoke of the defendant's past commitment to friends, family, and her church, and they detailed her giving and selfless nature. Dr. Abel testified that the defendant's offense was a situational crime, that it was not part of a larger pattern of criminal activity, and that the defendant was not likely to be a repeat offender with not a risk to the public and was amenable to rehabilitation. But the defense called 8 character witnesses from among the defendant's friends and family who all testified the defendant was mild-mannered, honest, and nonviolent. The defendant stated that she could not explain why she had put her babies in the laundry basket or that what was going through her mind, and she acknowledged that her responsibility and that she was sorry. The trial court sentenced the defendant to life sentence for each murder and to 25 years for aggravated child abuse conviction, and imposed all of her sentences to run concurrently. I'm trying to think about one thing. Okay, so the defendant moved for a new trial on numerous grounds. Okay, and then we found out she was... So, yeah, wow, this is... I didn't hear about this case. I wonder if this trial is on... So, let me see what the end of this is here. A lot of pages in this. Okay, but wow, let's go to our... That's... I don't know if anybody heard of that case. Did you guys hear of that case? Anybody? Hi, little lady. Hi, Holly. Margot. Hi, Astro from Space. Hey, family. How is everyone? Painted Black. Hi, 61. Kevin Leonard, Ready. I've never heard that case. That is something I'm going to look into a little more. Okay, but let me go to this other case now, okay? Because, oh boy. Miss Donaldsonville of 2023, Miss Donaldsonville. Hold on, somehow I just lost my... Okay, Miss Donaldsonville, here we go. Oh. Come on. Okay, so former Georgia beauty queen has been indicted for the murder of her boyfriend's 18-month-old son. So let's get her indictment here. Okay, so here's our indictment. Malice murder, felony murder, felony murder, aggravated battery, cruelty to children in the first degree. Grand jurors chosen and sworn for the county of Sumter. The grand juries aforesaid in the name and behalf of the citizens of Georgia charge and accuse Trinity Poag of the offense of malice murder for this said accused on or about the 14th day of January 2024 in Sumter County, Georgia, then and there did unlawfully with malice and aforethought cause the death of Romeo Angeles, a human being, by inflicting blunt force trauma to the head and torso of his body, contrary to the laws of said state, in that good order, peace, and dignity thereof, in violation of the laws of the state of Georgia. So let's see if they give us the background. Not there. Okay, let's see what she did here. Hang on. Okay, so she faces 6 counts: malice murder, cruelty to children, and 2 counts each of felony murder and aggravated battery. She was initially arrested in January after the toddler was taken to Phoebe Sumter Hospital in Americus. At the time, it wasn't clear how the 18-year-old was connected to the child. The boy, identified as Romeo Angelus, also known as Jackson Drew, was found on January 14th at a dormitory on the campus of Georgia Southwestern State University, where this Trinity was a student. The indictment says that Trinity caused the child's death by inflicting blunt force trauma to the head and torso of his body. The indictment further says that Trinity did severe damage to the child's brain, liver, and inflicted cruel and excessive physical pain upon the child. She was chosen as Miss Donaldson in 2023 and competed but did not place in the National Peanut Festival pageant. She was stripped of her title after her initial arrest. Okay, so, wow. All right, that's quite... Let me see where you guys are. Okay. So, was the father of the baby... Oh, I thought I know this case. Haven't wait. If I know this case, she was jealous of the baby. Which one? This one right here? That beauty queen one? Let me see what I can find about her. Hold on, I'm going to find out some more information. Okay, let's see. Let me see here. I just had that. Okay, let's see. The child so let me see here. Okay, so what happened, investigation indicated that an unresponsive 18-month-old boy was admitted to the emergency room at Phoebe Sumter Hospital in Americus. Hospital personnel performed life-saving measures on the child, however, he later died. I just read this about it, Americus. The child may have died from blunt force trauma, according to the Sumter County coroner, Mathis Wright. The deceased child's birth certificate identified him as Romeo Angelus. The Tot's father, however, gave the child the name of Jackson Drew at the hospital. Something about Americans. Hang on, my computer's being a little jerk again. Turtle just jumped in. Okay, hang on. Oh my goodness. Okay, I want to talk about that's what it's like. What is going on? Okay, come on. What is going on? Hang on. Trying to get this. I want to tell you about some other stuff. Okay, here we go. So yeah, he was, let me see here. I don't know how she had the child in her dorm room. That's what I just want to see. Why does she have the child in her dorm room? After conducting interviews and examining evidence, GBI agents arrested Trinity. She is the reigning Miss Donaldson. The victim was identified as Jackson J.D. Williams by Cecilia Smith, a close friend of the toddler's father. Smith set up a GoFundMe to support the grieving father, whom she identified as Julian John Williams. Smith said that Trinity was Julian's girlfriend and the child lived with his father full time. We are all very hurt and confused, just really in disbelief. And saying the father doesn't want to speak to anyone about anything right now. Trinity graduated from Southwest Georgia Academy prior to enrolling at Georgia Western State University. She is being held in the Sumter County Jail without bond. She faces charges of okay, she's been indicted on those charges, but it's they don't have all the information yet. Anyway, let me just. I'm gonna sneeze. Hold on a second. Okay, I'm back. So yeah, that's a sad situation. I wanted to talk about something about these shark attacks in Florida. So hang on a minute. Okay, so Florida authorities on high alert after 3 shark attacks in a single day, back to back, including a woman who lost her arm. So Walton County. I think this is near where Chris went on vacation. Cops in Florida's Panhandle are on high alert after 3 shark attacks in a single day left 1 woman badly maimed and 2 teen girls injured on the same stretch of coastline. I believe my friend lives out there too, and she was showing pictures of something that didn't look like that. It was cold when she went. Authorities temporarily closed the beaches and are patrolling the waters after the encounters, which left a 45-year-old woman with severe injuries that led doctors to amputate part of her left arm. They have since reopened, but cops say swimmers need to stay vigilant. Walton County Sheriff's Office is patrolling the waters after 3 shark attacks. The sheriff spotted a hammerhead in the water, which they say is not uncommon. The Walton County Sheriff's Office Beach Marine Unit continues to monitor the shoreline and the beaches Saturday following Friday's incident involving sharks. Deputies spotted a 14-foot hammerhead east of South Coast Highway in Santa Rosa Beach this morning from the boat, which is not uncommon. We want to reiterate that sharks are always present in the Gulf. Swimmers and beachgoers should be cautious when swimming and be aware of their surroundings at all times. Authorities posted red and purple flags on the beach to warn swimmers, red for high hazard and purple for dangerous marine life. In another Facebook post, the sheriff's office asked visitors to be aware of their surroundings and remembers we are guests in the Gulf of Mexico. The 45-year-old woman who suffered the most egregious injuries was swimming with her husband at Watersound Beach in Walton County at about 1:15 p.m. Friday when the shark struck. The attack caused significant trauma to the woman's body, and part of her left arm was later removed. She was airlifted to HCA Fort Walton Destin Hospital in critical condition. About an hour and a half later, a shark attacked 2 teenagers who were swimming with their friends in waist-deep water near the inlet beach about 4 miles away. The girls, ages 15 and 17, were both hurt, with one girl suffering significant injuries to her upper leg and hand. 2 doctors who were on vacation together happened to be in the water during the attacks and provided potential life-saving care to the wounded girl. Ryan Forbes and Muhammad Ali were boogie boarding in the water with their kids when they heard panic on the shoreline. We all started running out of the water, Forbes said. I grabbed my son, he grabbed his daughter, and then I looked over to the left as we were getting to the beach, and I saw red, cloudy water from the shark attack. Wow. When the doctors reached the sand, they worked with the other EMTs and trauma nurses who happened to be in the area to the desperately injured girl. When I looked down at her and saw the severity of her injury, I realized that anyone with that kind of medical knowledge needed to help. They applied tourniquets to the upper leg and hand, and they kept pressure on the bleeding wounds. Although Forbes and Ali said they didn't know the other medical experts they were working with, they worked together seamlessly. We might as well have worked with them for years. It was amazing. It was it was God's will that everybody was there to help at the same time. The victim was airlifted to Ascension Sacred Heart Pensacola Hospital in critical conditions. EMS Workers brought her friend, who only had minor injuries to her foot, to a local hospital for treatment. So be careful. Careful. Let me see what you guys are up to over here. Okay. All over the Gulf at Carolyn. Yeah. Absolutely. It was his dorm room. Oh, she was at his dorm room? Okay. But how they said he had full custody of his child in a dorm room? That doesn't make sense. How could he have custody of a child in a dorm room? I don't understand that. I'm going to have to look into that a little more. Yeah, that's a little bit crazy. How could he have custody? You won't go in at all, little lady says. Oh, I think about the stuff I used to do in the ocean. Oh my gosh. It's crazy. Crazy, I tell you. I'm trying to think if oh, I know what. Okay, now I remember something. Just trying to think about something about the ocean. And I'm just often deep in thought about something about some of the crazy stuff and how far out I would go. It's just nuts. That's big. What's big? The 14-foot. There's a big hammerhead. Okay, so let me go to see what else is going on. Yeah, but I want to figure out how he had custody in the dorm room when it said he had custody of that child. To get some more information on that. Boy thrown. What happened here? A boy thrown. Boy thrown from Tate Modern balcony, able to play by himself. What? What happened over here? A boy thrown from the Tate? The family of a boy thrown from the 10th floor of the Tate Modern Art Gallery say they are proud of his progress, and he is now able to play by himself. Oh, wait, he was thrown from the French youngster who was 6 when he was badly hurt in an attack by a teenager 4 years ago. The child was on holiday with his parents August of 2019, and he survived a 100-foot fall, but he suffered life-changing injuries, including a bleed on the brain and broken bones. His family calls him our little knight, and they said in an updated post on GoFundMe page that he has begun to choose activities for himself, and we are in awe of his courage. The boy spent months in intensive care, is said to be gaining maturity and independence. He can go to play in the garden with the dog, sit down and draw, build with his Legos, take a board game, or read in his room. He is more careful in his movements and in his actions in general, which allow him to start helping in the house by feeding the dog, for example, or clearing his plate. He's proud now to be able to open the shutters by himself and, above all, to finally access the refrigerator to serve himself dessert. The boy has gained strength on his left side, making him more stable when standing. This progress allows him to guide his horse a little alone at the horse-assisted therapy. Wow, that's crazy. Somebody threw him. Wow. Malice and F4. Yeah, Disneyland employee killed on job by reckless golf cart driver. What? Golf cart. Hold on, let's see. Come over here. Come over here. No, no, stay there. It says that a Disneyland employee died on the job when she was thrown off a faulty golf cart being driven recklessly through the backstage area of the Southern California theme park. Bonnie Mavis Lear, an administrator at the park's exclusive Club 33, suffered grave injuries when she struck her head around 11:30 a.m. She was rushed to the hospital and succumbed from her injuries 2 days later on Friday. Police had few details surrounding the accident, which they referred to as a traffic collision, but Lear's colleagues said she had been thrown from the cart when the driver recklessly struck a bump in the road. Wow. Lear was riding in the rear-facing seat of the brand-new cart as it rode 20 miles per hour behind Critter County, a temporary closed section of the park, when the car lurched. She went to grab the handrail. It gave way and sent her out of the vehicle. We do not know if the passengers were aware that she had fallen out. She suffered head trauma and a fractured skull that could not be quelled in surgery. Wow. The Disneyland employee also accused the Anaheim resort managers of telling cast members to stay mum about the circumstances of Lear's death. Wow. It didn't have to end this way. All of this mess could have been avoided if the driver of the cart wasn't driving recklessly. The golf cart from the entertainment department was brand new. How could it fall apart? It's so unfair to us and the family. Disneyland did not immediately respond to the post questions surrounding the various allegations. Lear had been a Disneyland employee for 24 years, most recently in membership support services at Club 33. The members-only club is comprised of several private dining clubs located within the various Disney parks and provides an opportunity for high-flying guests to escape the overwhelming crowds. We are heartbroken by the loss of Bonnie and offer our sincere condolences to everyone who cared for her, said Disneyland Resort President Ken Potruck in a statement. Wow, that's something. And then, then I've got to tell you about something else. So when we talk about this accident, a badminton racket accident, it's killed a child. Hold on, my computer's just being a jerk. Let me get some of these. Maybe I can shut some of these windows down here. Okay, so I'm going to tell you about I'm going to tell you about this badminton. Well, hold on a second. My Chrome just crashed. I hope my YouTube didn't crash. Hold on, I'm going to come and check. As soon as I can get up and running again here. As soon as I can get up and running. There we go. Let's see here now. First, let me make sure that you guys are still on. So I'm going to open my YouTube. That's going to be the first thing that I'm going to do here. Yes, we are still live. Second thing I'm going to do is to get back into live chat. Okay, and then I'm going to talk about this badminton accident here, okay? It's just like the neighbors of mine, their child almost lost their tongue with a frisbee. It's crazy. I feel like this happened already. I feel like I talked about this. I'm having like severe deja vu, and I think I remember telling you guys about the frisbee freak accident. So, the heartbroken father of a 6-year-old New Jersey girl who died in a freak accident while playing badminton has shared new touching memories of his bubbly and strong-willed daughter. Her personality was very bubbly and also reserved at times, said Jesse Morgan, a pastor at Green Pond Bible Chapel in Rockaway, New Jersey. The tragic the tragic death of his daughter Lucy. Once you got to know her, she was very, very outspoken and a lot of fun. She was a tough kid, played soccer really hard, he said on a Fox Digital interview on, on what day did you do it? Sunday. He recalled Lucy's penchant for affection, referring to her as the main cuddler in the family of 6. I just remember her coming up with her bedhead hair and just wanting to sit with you for a long time, not restless, just wanting to lie and snuggle up. The tragedy happened on June 1st, the last day of an otherwise picturesque lakeside family vacation in Limerick, Maine. A badminton racket splintered as little Lucy played with her 3 siblings in the front yard of the rental cottage, and a piece of metal pierced the little girl's skull. Oh my gosh. Emergency responders rushed her to a local hospital, which then airlifted the still breathing but unresponsive child to Maine Medical Center in Portland. She was taken directly to the operating room, where surgeons removed part of her skull to relieve the pressure when Lucy flatlined on the table. Although doctors were successful in reviving her, she had lost all brain function and the full ability to breathe on her own, and she succumbed to her injuries around 4 a.m. Wednesday, a day longer than she was expected to survive. Upon returning home from the life-changing trip, Jesse remembered looking at the photos of Lucy with his wife, Bethany, and their other daughter. My wife just made the comment that her beauty is haunting. Some of those pictures are just... She's just so gorgeous, and her personality is so incredible, he said. He described the family vacation up until the accident, which happened on the first week of his sabbatical, as the best week of her life. We did so many fun things, he recalled. That is really horrible. That's like what I'm saying. You think you're having such a good time or doing something, and then tragedy like that. It's just horrendous. Everybody's life has changed. It's terrible. Photos of the vacation Jesse shared on his blog show the bright smiles of Lucy and her siblings as his family climbed trees, hiked in the woods, and enjoyed a nap on a lakeside hammock. We did so many fun things. That is really, oh my gosh, that is so sad. How the heck? The handle was a separate piece from the upper portion, and it was loose, and it flew off the handle. Ugh. Yikes. Terrible. It's terrible. Hi, Kato. And then this Michael Mosley, it was a TV doctor. Have you heard about this? The widow of the TV doctor and columnist Michael Mosley said it's devastating to have lost her wonderful, funny, kind, and brilliant husband, and confirmed that he had been found dead on the Greek island of Symi after going missing on Wednesday. His body was discovered in a rocky area besides Agia Marina on Simi on Sunday after an extensive search led by emergency workers around a 30-minute walk from the village of Petty, where Mosley was last seen on CCTV. The 67-year-old TV personality was with his wife and friends on the beach on Wednesday, but after going alone for a walk to the center of the island, in a statement from his agent to the PA news agency, Dr. Claire Bailey Mosley said, "I don't know quite where to begin with this. It's devastating to have lost Michael, my wonderful, funny, kind, and brilliant husband. We had an incredible, lucky life together. We loved each other very much, and we were so happy together. I am incredibly proud of our children, their resilience and support over the past days. My family and I have been hugely comforted by the outpouring of love from people around the world. It's clear that Michael meant a huge amount to so many of you. We're taking comfort in the fact that he so very nearly made it. He did an incredible climb. He took the wrong route and collapsed where he couldn't be easily seen by the extensive search team. Michael was an adventurous man. It's part of what made him so special." She said the family are also so grateful to the extraordinary people of Simi who worked tirelessly to help find Mosley, with some working from dawn until dusk, unasked. Dr. Bailey Mosley added, "I feel so lucky to have our children and my amazing friends. Most of all, I feel so lucky to have had this life with Michael. Thank you all." And this is where they were staying. He was removed from the rocks on the right-hand side of the compound. Mosley's 4 children joined their mother, a GP and cookery book writer, on Simi earlier this week to help with the search effort. His body was discovered around mid-morning on Sunday beneath a fence that runs around a bar on that Marina Beach, which is surrounded by hilly, rocky terrain. Police arrived about 20 minutes after the body was discovered, about 90 meters from the coastline. Firefighters arrived at the marina just after 2 p.m. local time and took the body from the island on a stretcher on a boat. On Saturday, emergency services helicopters spent hours flying across the mountainous search and hovered over the spot where the body was later found. 38-year-old bar manager first saw the body alongside journalists after the island's mayor saw something by the fence of the bar and alerted staff. He said they saw it with the boat. The mayor came and saw something, so that is when they called me and said, "Hey, they saw something. Go there, check it out." They called me and they said, "We saw something from far away. Can you go check it?" So I went there. When I walked up there, I saw something like a body. To make sure you don't see a dead body every day, it's not a war zone, it's summer. You're supposed to have fun and swimming. Let's see. The search effort had been widespread, operating in dangerous conditions and high temperatures, and included police, firefighters with drones, Greek Red Cross workers, divers, and let's see here, what do we have? Search dog with a helicopter and a helicopter. Greek authorities shifted their focus on Saturday after CCTV footage from a house on the edge of the small marina showed the presenter walking towards a mountainous path at about 2 p.m. on Wednesday. New footage released on Saturday also appeared to show Mosley walking unimpeded with an umbrella near to the marina. Mosley first trained as a doctor in London before he moved into the media world, becoming a presenter and a documentary maker, author, and columnist. During his career, He presented a host of science programs and films, including BBC Trust Me, I'm a Doctor, which looked at healthcare in Britain, and hosted BBC Radio 4 podcast Just One Thing, where he revealed tips to help improve your health. The BBC's chief content officer, Charlotte Moore, described him as a brilliant science broadcaster and program maker who was able to make the most complex subjects simple. He was also passionate and engaging in entertaining audiences, inspiring us all to live a healthier, fuller life. His entertaining and accessible style was enjoyed by audiences around the world, and he will be hugely missed by many people, not least those fortunate enough to have worked with him at the BBC. So let's see. Whatever is going on here. Whatever else. What is this? Indiana serial killer made concerning purchase before burying 10,000. What? Indiana serial killer. Serial killer bought a hearse to pick up women for dates about 10 years before murdering his first victim. I feel like I heard somebody say that once. Herb Baumeister. Maybe it is this. Maybe I've already heard this one. I'd say it was 1970 or somewhere around there. I'm not really sure of the exact date, but Herb Baumeister Jr. purchased a hearse, and I could tell Dr. Herb Baumeister Sr., his father, was genuinely perplexed and a little, what can I say, concerned, said a woman who worked with his father in the surgery department of Indiana Hospital. She said the elder Baumeister was a gentleman who drove her home after late shifts or emergency surgery and looked out for her. When they worked together, the father told her tidbits about his son that seemed to weigh on his mind. And that was years before his son killed the first of at least 12 victims and buried their bodies around his Indiana property. I think we've talked about this. Baumeister Jr. is believed to have killed at least 25 people from the 1980s to the 1990s and buried them throughout his $1 million 18-acre property called Fox Hollow Farm in Westfield, Indiana. Law enforcement recovered 10,000 burnt and crushed skeletal remains after Baumeister Jr. shot himself as police closed in on him. So far, the Hamilton County Coroner's Office has identified 8 victims, and investigators have found 4 more DNA profiles that have not been properly identified yet, which brings the body count up to 12, according to the coroner, Jeff Jellison. Looking back, that father's friend remembers several conversations in which Baumeister Sr. seemed concerned about his son. The hearse was the most vivid in her mind. And this was the house that was there. It was a Tudor-style house. She said the father asked his son why he would get a hearse, and his response was, "Well, Dad, it's a good way to get around and go on dates." There were other red flags that she can see in hindsight now. She said that she was close in age to the son. She felt that the father spoke to her to get a younger person's perspective. She said that the son did not appear to have many friends. People did not come to the house or want to hang out with him. He did not play sports at a high school that was an athletic juggernaut or participate in extracurricular activities and struggled to maintain his grades. He flunked out of college after one semester. His dad pushed him to go back to school in the late 1960s to study anatomy, but he did not make it through the first semester. I know that Dr. Baumeister was very disappointed when his son dropped out, she said, and I think it's as if the son didn't want to bother with school. She met the serial killer once when he was in college, but she doesn't remember anything out of the ordinary or college age. He came to her house once and spent about an hour talking about mundane things. She noticed that they were mostly topics he picked. She came away thinking he was polite, courteous, and a nice-looking man. It's hard to get my mind wrapped around the fact that something like this, even after all these years. At one point, she fought back tears. I knew Dr. Baumeister very well. He was just a kind person, and it's hard to imagine his son doing these incredible crimes. Okay, let's see. Was committed to 6 months after. So in 1971, the son was committed to a mental institution after he married Juliana Sater. She struck with him during his treatments, and by 1984, he was a married dad of 3. The serial killer was, okay? He had achievements at different jobs, but some odd behaviors, such as urinating on a letter addressed to then Indiana Governor Robert Orr shortly after a promotion in the Bureau of Motor Vehicles, ended his success. He started his job after the incident, but he and his wife essentially switched roles. He became the stay-at-home dad while she went back to work. Let's see. The couple ultimately founded a profitable thrift store which changed their lives. Thrift store, look at that. He's a serial killer with a thrift store. Oh boy. In the 1990s, Baumeister and his family moved into the $1 million 18-acre home, but their marriage began to crumble. He stayed behind to care for the stores and the house, which is where he committed most of his murders, while his kids and wife left for long stretches of time to get out of a toxic environment. That's when his double life started. He used the name Brian Smart when he hunted for his prey in gay bars in the Indianapolis area. I think we talked with somebody about this guy. I remember this. Thought he was going like between 2 states, wasn't he? That's when he picked his victims up. He brought them to his spacious and secluded home and ultimately killed them and buried their remains. One day in 1994, his teenage son found a skull and showed it to his mom. He initially brushed it off as an anatomical skeleton that his father owned. Of course, we all know there's no such thing as owning an anatomical skeleton. They're carefully handled. But his wife believed the excuse, but she became suspicious. She initially denied law enforcement's request to search the premises, but their son's chance discovery of the skull was trapped in her mind like a fly in a spider web. Let's see. The business went downhill. The couple faced bankruptcy, and the son was consumed by alcoholism. All this led to the divorce and his wife going to the police with the skull. Law enforcement closed in. There was a warrant for his arrest, search warrant to dig up the property, and then he fled to Canada where he shot himself. Huh. That's crazy. A ranger died after falling in a Utah National Park, Bryce Canyon National Park. A park ranger has died after tripping and falling while on duty. He was 78 years old. Wow. He was working over here. Tom Lorig. He was working during Bryce Canyon's annual astronomy festival on Friday, and he was directing a visitor to a shuttle bus around 11:30 p.m. when he fell and struck his head on a large rock. Wow. He began working with the National Park Service in June of '68 at Carlsbad Caverns National Park in New Mexico. Since then, he had worked in 14 more national parks, including several in Utah. We want to express gratitude to the National Park Service and Garfield County Emergency Services who responded, as well as the bystanders who assisted NPS first responders. Oh, that's sad. Okay, so let's see what you guys are doing. Holly's over there. She's talking. Also, I was in Top Chat. Silly me. Sorry for the delay. Hi, Christine. Hello, Sassy. Let's see. Kate O, hi. So, wow, all of that. That's some crazy stuff, but I think we need, well, first I think we're going to do the daily puzzle to unwind a little bit, and then I have something else planned in a second. I have something else planned. Do you want to find out what it is? They said that was in Utah, Holly. Which one are you talking about? The one he fell in? It said, wait, this is not the daily, is it, Kevin? No, probably not. Okay, and then we've got to have index, right? Let's see. Let's see. Diner. Okay, and oh, we did it. We did it. Windbag. Windbag. Oh my gosh, that reminds me of something. A windbag. Hi, Emmy. Hi, Carolyn. Can you move the top banner? Oh boy. The top banner, huh? Oh boy, let's see. Oh no, 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 no. How about if I just... Let me see. Alright, let me just... Which one is the one? Which one is the one? Okay. It should be okay. Yeah, alright. It should be okay, no? Okay, no? Okay. Oh, dawn, a new day, a new dawn. Dawn. big. Okay, and then what do we have? Big, bin, right, big ban, and then, oh, bid. Right, and over here we need G, G, no. What is this one? It's, oh, gnaw, yeah, gnaw. Yeah, very good. Safari, high 61. Yeah, that's good, high 61. Safari. This one is weird. Oh, labor. No. Blur. I tried oral. It went, yeah. Oh, or maybe, yeah. Up, yeah. Oh, good. One loan. I did loan. Oh, hold on a minute. Eon, yeah. 61, right? Eon, Ion. Ah. The veil. Yeah. We just got a couple of others. Let's see. Has to be with a V. Oh, wait a minute. Vi. I did. Well, okay, I'm suddenly so sleepy and I've got to put 2 labels on 2 packages. I have to go to sleep. So I will see you guys tomorrow. Love you guys. God bless. Prayers. I can't believe it's 2:26. I thought it was earlier. Have a great night. I love you guys. God bless. I'll see you tomorrow.